14th Amendment due process rights. Make a reservation for those rights, especially, but all rights at this time.
The record to reflect that the individual known to this court as Darrell Brooks is present in person, in custody.
And I don't consent to being called that name for the record. This paperwork I accept for value and return for value, as it does not state the correct name. It states the name of my client, the straw man. I am not this name in all capital letters. I do not identify by that name, nor do I know that individual.
Your objection is noted. It's baseless in law and fact. That is simply a caption on a pleading on the final jury instructions.
That is not my name for the record.
All right, the record should reflect, Mr. Brooks, I'm talking. The record should reflect that at 3:23 p.m. yesterday, all of the verdict forms were printed off and provided to Mr. Brooks. I also provided him with an excerpt from the bench book on closing arguments about that time in the proceeding for the parties to give their closing arguments.
Your Honor, I accept for value and return for value any documents that you just alluded to. I have not seen them.
Mr. Brooks, if you haven't seen them, that is by your choice. They were provided to you. I know on multiple occasions yesterday you threw items into the garbage can, had them placed on the table this morning, and any other items you threw in the garbage.
So is that the paperwork that I had to stay here for over an hour for?
Sir, I'm not going to discuss any further what we did during the jury instruction conference. The jury's going to be brought out a little bit later.
There was a conference. We talking about the proceedings from yesterday or after you had told us we recessed?
Mr. Brooks?
I'm referring to after you called recess for the night yesterday. That's what I'm referring to. I was put in the holding cell for over an hour because they said it was some paperwork that needed to be.
That is correct, sir. You were kept there in order for my clerk, who had to finalize 76 verdicts, 2 each, 1 not guilty, 1 guilty, and provide those to the parties. And so that's why you were kept there, so those could be handed to you. My understanding is they were. I would need a bailiff to confirm for me whether he took those back to his cell or if they were put on his desk because he left them in the holding cell.
Left them in what holding cell? In here? What holding cell are you referring to, Your Honor?
Behind the door.
I didn't leave anything in that holding cell. I was just trying to figure out why I was in there so long.
Are those the verdicts? Yeah. All right, he has those. Thank you.
Is this the paperwork that was just put on it was paperwork on the desk when I came in. That was on top of my folders.
Mr. Brooks, I know that you were given the opportunity to take them to your cell because that is what I was advised. Whether you did that or not, I don't know. But they are also on your desk now. I
accept for value and return for value any documents.
We did discuss all of the jury instructions and the verdicts yesterday.
So what was discussed when I was in the cell for over an hour?
There was no discussion, sir. The court was in recess.
I was told that I had to stay there per you.
Yes, so that we could provide them to you and you would have an opportunity to take them back to your cell.
But can they have been delivered to the jail?
All right. I don't believe there's any other preliminary issues we need to address other than an advisement I will have for Mr. Brooks. But let me turn to the parties. All right. Anything else from you, sir?
Yes, there is. Yesterday, I stressed to the court numerous times about me not understanding the proceedings and essentially how decisions are being made on my behalf without my understanding or giving consent.
The court made various rulings yesterday. I stand behind the record that was made. I'm not going to explain it further.
So a lot of those decisions were made when I was not present in the courtroom. I was in the other courtroom, correct?
That is true, sir.
Is that correct?
The record will indicate when those were made and where you were.
I can't see the record, though. How am I supposed to know what the record will reflect?
The decisions were made yesterday. I'm not revisiting them today.
They need to be revisited, and it also needs to be talked about subject matter jurisdiction that has yet to be proven for the record. I'm still trying to understand, Your Honor, how you made a judicial determination on my behalf, which I did not give consent to, as you say, I forfeited my right to testify, which I never did. I never said I wanted to. I never said I didn't want to, but that decision was made for me. Also, the decision for the defense to rest its case was made for me, which I did not consent to, nor did I say I was ready to rest, or nor did I say I was ready to rest. I'm trying to understand how all these decisions are being made without my consent, without me waiving any rights. I'm not understanding how, because none of my answers were unresponsive. I just didn't answer the way that Your Honor wanted me to answer, but I stressed yesterday, if I don't understand something, how am I supposed to answer a question that I don't understand fundamentally? It's not me saying yes or no, and it's not me saying, okay, I want to waive this or that right. And I'm not trying to make an argument with you in any way. I'm just seeking to understand how these decisions are made, if I'm letting the court know and I'm putting the court on notice, hey, I don't understand this or I don't understand that.
Any other things? Otherwise, I'm prepared to address each one of those.
Yeah, there was a mention of if there is a conviction in this matter, there is a mention of sentencing, which I'm assuming there'll be some type of people may want to speak. I know if there is a conviction on my half, people will definitely want to address the court. There'll be a lot of affairs that need to be put in order, obviously on my side. If it pleases the court, if there is a conviction in this matter, I would like the sentencing to not be so quick. I'm asking if it pleases the court for the sentencing to be held off into a later time, not a day or two or a week, just so that affairs can be put in order properly and so that the people that want to come in and speak will have the opportunity to address the court.
I think
If
that's a
that
fair
pleases,
request, sir.
if that pleases.
I think that's a fair request. I thought about that and some more overnight, that in the event there is a conviction, that I would like to give the parties an opportunity to do that. I have no idea how many people would want to speak. My inclination would be, again, and this is not set in stone, if there is a conviction on any of these counts, I may ask the parties to just come back in on Monday, October 31st, with kind of a proposed plan of how many people do you think will speak on your behalf, how long do you think it will take, so that I can look at my calendar and then set aside the appropriate amount of time. I certainly don't want to rush anything, and I think that's a fair request that you're making.
Thank you.
All right, so with all of that then, sir, subject matter jurisdiction, I decline to address that further. So to the extent that you are asking me to reconsider any of that, that's how I would interpret your statements here today. I decline to do so.
So, Your Honor, would that be, that's still not, I have no understanding to why I wasn't given the opportunity to place certain things into evidence. I have virtually nothing, zero evidence that I was able to place into evidence. Nothing.
I disagree with that, sir. You called, I think, 9 witnesses on your behalf on various issues, including the honking of the horn, the window tinting. You cross-examined many of the state's witnesses about police barricades and the presence of police. So you did present evidence.
I'm speaking to the terms of everything that Your Honor asked me to do. You told me to put everything that I needed to present to the courts in writing. You made that ruling. You told me that's what I needed to do. I did that.
Mr. Brooks, you may have interpreted that. I did not require you to do that. As far as evidence in the case, I very expressly told you there are rules of procedure and rules of evidence that govern exhibits, testimony, witnesses, etc. What I told you is that any requests that you have related to the case, if it's a motion, be put in writing. I specifically referenced the statute 80201 regarding how a motion is made and what it should contain, meaning it has a very express request for relief and states the law and the facts upon which the request is being made. Again, I'm not going to revisit the prior ruling. I stand behind them, and to the extent that the record does not have, meaning the record before the jury and the evidence does not have certain pieces of information, evidence, or testimony that you wanted to present, you forfeited that opportunity yesterday based upon your conduct.
How did I forfeit the opportunity?
Again, I'm not going to revisit that, sir. What I will tell you is this.
How did I forfeit
This
the
jury is
opportunity
here.
to be able to place into evidence?
Mr. Brooks, I'm not going to debate this further. I'm
not trying to debate. I'm trying to understand.
To respect the fact that I've made rulings.
Your Honor, that's you
It's
made
not
a
my
judicial
job to
determination.
explain them
You made
to
it.
you.
I'm not asking you to explain anything. You're misinterpreting what I'm trying to ask you and trying to tell you. You're misinterpreting it. With all due respect, Your Honor. When you tell me this is what you need to do, I'm going to take it by what you're telling me that I need to do. If I needed to make anything request-wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before, when would I have a chance to present things into evidence, you told me we were not at the evidentiary phase of the trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things in the evidence that need to be put in evidence for the record. So I'm not understanding how a decision can be made for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that, quite frankly, allow me to put on a defense. Things that need to be known, things that should be in the record, as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. It was a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that, I did what Your Honor asked me to do. And these are things that were part of my defense that needed to be placed into the record. So where my confusion comes in is not being able to place those things into the record. Things that clearly help my defense.
I stand by my ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings.
So how am I supposed to put these things in the record that need to be in the record?
Mr. Brooks, I'm well aware of the effect my ruling had, and I'm not going to debate it with you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr. Brooks, I'm no longer going to talk about this.
I'm just seeking to understand.
Mr. Brooks, I cannot explain procedure or evidence
the filings that I filed.
Rulings or
I'm
the
asking
law
a question, Your Honor.
you.
I'm merely asking a question. The filings that I presented to Your Honor.
Any filings with this court are in the court record. That does not mean they're evidence, sir. And I told you
that's
that
not
previously.
what I'm asking. I'm asking, are the filings part of the record? The filings that were filed and timestamped, that were notarized, that I presented to the court. All the filings, the appearance bonds, the statement of particulars, the notice of special appearance, the court docket sheet, your oath of office, everything that I tried to present into the record. How am I not able to make them part of the record?
Anything that was not offered as an exhibit and received during the evidentiary phase is not evidence in this trial.
That's what I attempted to do, and you told me that I couldn't. You told me,
Mr. Brooks, I am bringing this jury
Your Honor,
out.
with all respect, you told me that we were not at the evidence. When I said I have exhibits as well, I have stuff that I want to put into the record. I even asked, I said,
Mr. Brooks,
may I give an offer into evidence?
I'm going to stop you once again. I'm not going to have this discussion and debate. The evidentiary phase of this trial is closed.
It should not be, though, Your Honor.
I understand your lack of consent. Your objection
so when would I be able to put?
for the
When
record.
would I be able to put vital information into the record, which I haven't had the opportunity to do?
That opportunity has closed for you, sir.
So you saying basically you're prejudicing my defense by me not being able to present things into evidence, offer into evidence, filings, and important paperwork and documents.
Mr. Brooks, and you forfeited your right to do that by your conduct yesterday, and I stand behind that decision. I'm going to do the following, sir.
Your Honor,
I'm going
I
to
asked
do the
this
following.
before yesterday.
You have not honored my request to you that you cease debating me on prior rulings.
I'm not trying to debate.
Court.
I'm trying to understand why my due process is being violated.
Mr. Brooks, the record speaks for itself.
No, the record does not.
I am going to take a 5-minute recess. When I come back out, the jury will also be coming out. There will be no multiple opportunities where I give you to conform your conduct to the rules of decorum and courtesy.
Then just hold me in contempt, then, Your Honor.
You are
hold me in contempt, because I didn't even. I'm trying to seek to understand.
Start talking about subject matter jurisdiction or any of these other
issues. It needs to be addressed,
or
Your Honor.
in any way
we're not talking about subject matter jurisdiction. We're talking about why my due process has been violated.
I will excuse the jury and you will be removed to the other courtroom.
We're talking about the 14th Amendment, Section 1.
I am taking a 5-minute break. We are
Your
in recess.
Honor, I don't agree to a
estoppel.
I don't agree to a estoppel. Your Honor, as a Your Honor, it has yet to be proven for the record, and upon your refusal, that would be looked at as dishonor.
I'm not addressing it. The jury's coming out.
So is that a tacit agreement that you don't have to answer any questions as a public servant, Your Honor? Therefore, that's dishonor. Are you going to honor your oath of office?
Stand. I'm not addressing it further.
Are you going to honor your oath of office?
All right.
So I'll take that as a tacit agreement that you're not going to honor your oath of office.
All right, I'm going to have to excuse the jury. Mr. Brooks, I warned you that if you made any interruptions when they came out, you would be removed to the courtroom. That's what I'm doing right now. You're forfeiting your right to be present in this courtroom unless you can promise me right now you will respect prior rulings of this court and not interrupt this next phase of the trial, which is the court reading the jury instructions without interruption from you. Can you do that?
Have I acted in dishonor, Your Honor?
Mr. Brooks, I very expressly warned you.
Have I acted in dishonor?
You have disobeyed a direct order from this court.
Have I acted in dishonor?
You have disrupted these proceedings.
I have not disrupted these proceedings.
Sir, can you pledge to me that when this jury comes back out, that you will remain silent and not reference things like subject matter jurisdiction, the court's oath of office, tacit agreements, or anything? Can you pledge that you will respect these proceedings and this jury by not interrupting?
Have I acted in dishonor, Your Honor?
I will ask you one more time. Can you pledge to be quiet, sir?
Why should I have to make a pledge, Your Honor? Have I acted in dishonor?
Because under Illinois versus Allen, I believe you've already forfeited your right to be here, but you can reclaim that as soon as you are willing to conduct yourself consistently with the decorum and respect inherent in these proceedings, which at this point in the proceedings, sir, all I am doing is reading through the final jury instructions. I do not want that process interrupted by statements by you that are frankly misstatements of the law.
If they're misstatements of the law, Your Honor, how come they haven't been proven for the record? And I'm asking, have I acted in dishonor?
He refuses to answer the questions.
Have I acted in dishonor,
I have given
Your Honor?
him an ample opportunity to do so. He has forfeited his right to be present for the reading of the jury instructions, and he is to be removed to the neighboring courtroom. We will be in recess until that takes place.
Your Honor, have I acted in dishonor?
Everyone, please be seated. The record should reflect that Mr. Brooks has been placed in the other courtroom. He is presently on mute so that I can make a record. Yesterday, this court held a jury instruction conference to raise objections regarding any of the proposed jury instructions, to make requests regarding inclusion of any jury instructions that the court did not include, as well as review all of the verdict forms. There's absolutely no reason for there to be an interruption or an objection to this process at this time. I am currently being advised that he would like to come back. That, of course, is always something that I will give him. As soon as I make my full findings, I will pause, and he will be brought back into this courtroom so that he can be in attendance when the jury is brought out. We will take a pause, we'll recess, we'll come back in when he is set up in this courtroom. Thank you, everyone. Please be seated. I'll have the jury brought out then. Record to reflect, we are all back in this courtroom.
Before the jury's brought out, can we address subject matter jurisdiction, Your Honor? Before
Absolutely
the jury's
not.
brought out,
Absolutely not.
is that a tacit agreement that you don't have to answer those questions as a public servant, Your Honor? So are you going to act in dishonor?
Mr. Brooks,
Are you going to act in
I've
dishonor?
already addressed your requests.
It hasn't been proven for the record, Your Honor.
The jury is on its way,
They're not out yet, though.
but they're on the way.
You held me in contempt.
I'm not
You held me in
addressing these
contempt
matters,
before-
sir.
Have I acted in dishonor, Your Honor? You held me in contempt without me being in dishonor. How have I dishonored the court? Have I acted in dishonor? Have I rose my voice or argued with Your Honor? Have I disrupted the
Mr.
courtroom
Brooks,
in any
you're
way?
back in this courtroom at your request. The jury is coming out.
I never should have
Please
been.
be respectful of their time, of
I have
this process,
been. They weren't even
and the
out
dignity
before.
of the proceedings.
They weren't even out before when I was trying to address what needed to be
Mr.
addressed
Brooks,
before they came out.
You're just
Am I
attempting
acting
to
in
disrupt
dishonor?
the proceedings.
Am I acting in dishonor? It's a tacit
All
agreement
rise
that you
for the
don't.
jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant, right?
All right, the jury.
No
is
jury's
not
out.
Mr. Brooks.
No jury's
over the
out.
door.
I was trying to
Mr.
address
Brooks,
this before they
right
came
outside
out.
this door. I am not going to do this with you this morning. You either
I'm not
abide by
doing-
these rules
Am I
and
acting in
stay
dishonor?
quiet,
Am
or
I
you will
acting
be
in
in the other
dishonor?
courtroom.
Am I acting in dishonor?
Yes, you are acting
How?
in dishonor.
How?
You are disobeying the direct order of this court to respect the decorum and the dignity of these proceedings. You are merely attempting to delay.
I don't care what you think. That's not accurate.
Mr. Brooks, I am having this jury out.
And-
And if you
and you're
say
making-
one word when that door opens,
You're making a tacit agreement.
then you will forfeit your right to be present.
So you're acting in dishonor, then, Your Honor.
All right, the jury may come in.
You're acting in dishonor by making a tacit agreement that you don't have to answer any questions as a public servant. You're not holding up to your oath to protect the
All right, the
Constitution.
door is open and he's talking.
Okay, so you're going to hold me in
All right,
contempt?
the jury cannot come in. Never mind.
Are you going to hold
All
me in
right.
contempt?
Mr. Brooks is going to be removed. We're in recess until that
How
can
am
be
I, how am
accomplished.
I acting in dishonor?
everyone. Please be seated. We are back on the record. Appearances are as they were before. The record to reflect that Mr. Brooks is now in the other courtroom. Given the importance of the proceedings and the need for the court to advise this jury without interruption, he was removed once again. I will not bring him back into this courtroom unless he is willing and pledges to conform his conduct and pledge to not interrupt by making any statements when this jury is present and during the court reading all of the jury instructions. I will unmute him so that he can indicate what he would like to say to the court. You are unmuted, sir. Go ahead.
Can y'all hear me?
We can.
First of all, at 9:25, I would like the record to reflect that the prosecution was making disparative remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that that is very disrespectful for the record. And again, I'm trying to figure out how did I act in dishonor to be removed from the courtroom? How have I acted in dishonor? This is a whole nother, how have I acted in dishonor?
All right, I'm going to mute Mr. Brooks. I'm not going to answer that question. I've made my ruling as far as anything that was done by the prosecution. I was not in the courtroom. The jury was not present. Whatever happened, if anything at all, was done outside the presence of the jury. If there is anything the state wants to put on the record right now, I'll give you that opportunity. Otherwise, I am going to bring the jury out. Mr. Brooks, if you want to come back into this courtroom, you need to write your request down on a piece of paper, and when you do that, pledge to this court that you will not interrupt these proceedings. Without that, I will not bring you back into this courtroom. I intend to have the jury brought out. I need 1 moment before I do that, and so I'm going to just take about a 2-minute recess. All right, we are back on the record. Appearances are as they were before at 9:45. Mr. Brooks sent a note that says, under Illinois v. Allen, I request for the second to be present at my trial. I never consented to not being present, nor did I act in dishonor, because he has not made a pledge to conform his conduct as is required under Illinois versus Allen. He has not reclaimed his right to be present, and we will continue with him in the other room. All right, with that, then the jury will be brought out. I'll remind Mr. Brooks, while he can reclaim the right to come back into the courtroom and make a request, I am going to be adamant that his request include a statement that he's willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings, and specifically pledge to not interrupt the reading of the jury instructions. Until such time, he will remain in that courtroom. All rise for the jury. Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law. The defendant is charged with 6 separate counts of first-degree intentional homicide, use of a dangerous weapon. The first count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Virginia Sorensen. The second count of the information in this case charges that Darrell E. Brooks did cause the death of Leanna Owen. The third count of the information in this case charges that Darrell E. Brooks did cause the death of Tamara Durand. The fourth count of the information in this case charges that Darrell E. Brooks did cause the death of Jane Coolidge. The fifth count of the information in this case charges that Darrell E. Brooks did cause the death of Wilhelm Hospital. The sixth count of the information in this case charges that Darrell E. Brooks did cause the death of Jackson Sparks. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. You cannot look into a person's mind to find intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. We are back on the record. The jury has not been brought out just yet. I indicated I would address a note that was passed by Mr. Brooks to the court. In it, he indicates the following: I have reclaimed my rights, parenthesis, that I never gave up or consented to give up, parenthesis, to be present, and you have not honored your oath of office to protect my constitutional rights, specifically my 14th Amendment, Section 1, which references equal protection of the laws. Would you like to explain this on the record, or should I? I will if you won't. I would like to make an offer of proof for my appeal on the record. I indicated previously that should Mr. Brooks want to come back into this courtroom pursuant to Illinois versus Allen, he could certainly reclaim the right to be present, but he would need to be willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. I specifically advise that he would need to pledge to not interrupt the proceedings. He has not done that, meaning he has not indicated he wants to come back, or that he will pledge to be courteous and follow the rules of decorum, and specifically pledge to not interrupt as I read through the jury instructions. And his letters or notes that he passed will, of course, be made part of the record, but I'm going to deny his request to make a further record for appeal, as I need to continue advising the jury of the jury instructions. So with that, Mr. Brooks will remain where he is at. Anything further he wants to address, he will need to do that in writing, as he has done with a note, but I don't feel the need to give him any additional opportunity to explain that. What I will ask is he going to make a request to come back into this courtroom? And if that is true, he can give me a thumbs up sign, and then I will address that. All right, I will unmute him. Mr. Brooks, what is your request as it relates to coming back into this courtroom?
I've requested to come back into the courtroom with the first writing that you said I had to write.
I put that on the record already, sir. You did not pledge to respect the rules of courtesy and decorum and pledge to not interrupt the court. Are you willing to pledge that at this time?
Your Honor, with all due respect, I've never had to do that before to reclaim my right. I've always asked, when you've given me the opportunity, when I felt that the time was right, I've always asked to come back. Have I not?
Mr. Brooks, given your conduct this morning and your blatant violation of my direct order to you to not interrupt when the jury was being brought out, I felt it important to strictly enforce the language of Illinois versus Allen and only bring you back if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, and specifically pledge to not interrupt as I go through all of these jury instructions. If you're willing to do that, I will bring you back in.
Your Honor, with all due respect, can we at least be fair and say today hasn't been as volatile as other days, or as the back and forth between you and I hasn't been what it has been previous?
Mr. Brooks, we started the advisement to the jury an hour later than I anticipated, so I would thoroughly disagree with you that it might not have been volatile or loud, but it was nonetheless disruptive. I will ask you these questions. If you come back into this courtroom, are you willing to honor my request and order to you that you not interrupt as I read through the jury instructions?
Your Honor, I don't understand the question that you're asking.
Sir, are you willing to refrain from raising the issue of subject matter jurisdiction if you come back into this courtroom?
Your Honor, with all due respect to your ruling on Illinois versus Allen, that was not part of Illinois versus Allen. I don't understand why that's being
Mr. Brooks, I'm not going to debate the meaning of Illinois v. Allen with you. I'm simply trying to get you back into this courtroom. You seem to want to be here, but you don't want to pledge to follow the rules of courtesy and decorum. So that's on you.
Your Honor, this has never been done before. It's never been done before, and I've always been able to reclaim my right to be able to be present.
Are you willing?
Which is what I stated when I first came over here. I've been stating the same thing. I've actually told the bailiff numerous times.
Mr. Brooks, I am strictly enforcing the language of Illinois versus Allen, which says the following. I will repeat myself again. Once lost, the right to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. I have not required the pledge previously. I've allowed you to come back, but given the interruptions this morning and your immediate discussion of things like subject matter jurisdiction, jurisdiction and my oath the minute one juror walked through that door, I cannot take that. I will not bring you back in without that pledge.
So where does it say anything about a pledge, Your Honor?
Sir, I'm not going to debate the language with you. I am establishing what I believe is a reasonable restriction on your right to come back into this courtroom based upon the history in this case of your repeated violations of the simple rules of courtesy and decorum and your failure to follow my very clear and direct requirement this morning that you not interrupt the reading of the jury instructions and you be silent once the jury entered the courtroom. I did that in part because it not only preserves the dignity and decorum of this trial, it also frankly protects your rights and it minimizes your bad behavior in front of the jury.
Your Honor, I didn't interrupt you while you were talking. I let you make your record without talking over you or interrupting.
Thank you. I would agree with you just now.
The way that I'm interpreting when you reference to me the Illinois versus Allen where your ruling is coming from, the way that I interpret that is not the way that you're saying it to me now. That's why I don't understand what you're asking. I'm interpreting that in a totally different way.
I'd refer you to the third section of Illinois versus Allen where the U.S. Supreme Court was discussing what the trial court did in that case, and it said the following: the trial court in this case decided under the circumstances to remove the defendant from the courtroom and to continue his trial in his absence until and unless he promised to conduct himself in a manner befitting an American courtroom. As we have said earlier, we find nothing unconstitutional about this procedure. So that is the authority, sir, in addition to the other quotation. I'll tell you this. I'll give you one more opportunity, sir. You can come back into this courtroom, but I do not want you to address or attempt to address subject matter jurisdiction or any of the other rulings that I've previously made. I need to continue with the advisement to this jury about the rules that govern their deliberations. That is the stage we are at. And if you violate that in any way by raising any of those legal issues in their presence, that will be in direct violation of the requirement for you to reclaim your right, and you will be removed back to the other courtroom. Did you hear me say that, sir?
I'm informed, but Your Honor, now you just stated on the record if I raise these issues in their presence, but if they're not in the courtroom, it's not in their presence, correct?
Sir, I can't bring them into the courtroom until you're here. I expect you during that short interval not to raise these legal issues that I've already addressed multiple times. So yes, I'm telling you, if you come back into this courtroom, I don't even want to have you raise any of those issues. I want to bring the jury right out without interruption. That is my clear expectation, whether the jury's in the courtroom or not.
Your Honor, I'm confused because you just said don't raise any issues in their presence, and now I'm confused.
Because you're indicating to me by your statement that you intend to raise them once you get back into this courtroom. And so I'm making that another restriction, and you need to pledge to me that you will not do that.
Your Honor, the way that I'm interpreting what you just read to me from the other section that you just read from Illinois v. Allen, it does not have that language. So I'm
Mr. Brooks, I'm not going to debate the language. Do you want to come back in here or not?
I've stated numerous times that I shouldn't even have been brought over here anyway and that I wanted to come back. But now what I don't understand about it, Your Honor, is that there's being rules enforced.
Mr. Brooks, do you want to come back in here or not? It's a very simple question.
I said yes already.
All right, then I'm going
to say the same thing.
Because then you go on and make other statements, and then I can't even effectuate your request.
But I'm trying to tell you how I'm interpreting what you're saying to me. If you want
Mr. Brooks, I'm going to mute you. We're going to go in recess. He can be brought back over, but I will advise you that if you start back in, even outside the presence of this jury, with any of the legal issues I've already ruled on, you will go back to the other courtroom. It's that simple. So we'll be in recess. He'll be brought back over, and then we'll start back up. All right, it's 2 o'clock. I'll call the case. State of Wisconsin versus Darrell Brooks, case number 21 CF 1848. May I have the appearances, please?
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell. This is a social security, cestQ, trust action, which you are a real party and interest to. as sujurus in propria persona. This is a military admiralty tribunal in maritime law. And the Title 4 of the United States Code Section 1, which you can see, which states placing of fringe on the national flag is within discretion of president acting as Commander-in-Chief of the Army and Navy. Is this a common law court or an admiralty court?
The records reflect that the individual known to this court as Darrell Brooks is present in person in custody. The court is not going to address any of the issues that he is raising, as they are meritless. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name, and it is not me myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor. And we still have yet to address subject matter jurisdiction, which has yet to be proven on the record. May I receive those original copies time-stamped?
All right, I need to make a record of one part of a jury instruction. Madam Clerk, if you haven't already, if you could print off page 72.
I accept for value in return for value this document, and Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all respect, the state received copies. How come I can't receive the copies of my filings?
You know what? I can give you the print-offs, but I can't give you the originals right now. Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the various rules and case law that govern closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right, then with that, I will have the jury. Oh, go ahead. Looks like Attorney Opper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
He's going to put it like right here, and then you want me standing at this table during...
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long as...
Yeah, I was going to put it like right about here so that he could still see me and the jury.
With that caveat, yes, I will allow that.
All right.
Objection. What is that? What is supposed to be put up?
They're previously admitted, Your Honor. It's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but I'm saying
of,
I don't understand what's being shown. Should not have the right to object and ask what it is that's actually going to be shown.
The state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing argument.
So can I put up exhibits?
Mr. Brooks, I don't know what you have planned for your closing argument. So
I'm making a request, the same request. May I be able to put up
Well,
exhibits?
I guess it depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is once the state goes through its closing, I may take just a short comfort break depending on how long it is. And if there's something in particular, you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously. It's just not nothing that the state has.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The Closing arguments are to direct the jury so that they have your arguments so that when they go back to determine, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty. All of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. Evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. The arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the fact. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal.
I'm not allowed to make the record at all, Your Honor.
Sir.
I'm not allowed to make the record at all, as I just let you did, because some of the
Sir,
issues has been
what you want to do.
Your
I've
Honor.
told you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and is unlawful law. You haven't shown one time that is lawful for you to do what you've been doing, as far as your ruling.
Once again, I'm not going to debate with you the prior rulings of this court. There is absolutely no need at this point for you to make an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you will have an opportunity, if convicted, to raise
the jury.
Every issue.
Contempt. Hold me in contempt. I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the mute button.
Reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings, whether
Your Honor,
he agrees with them or
I haven't
not.
dishonored the court. I'm merely exercising my right under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm
the way that
not
you have
disrupting
through
the
the course
proceedings.
of
You just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not even
the
in your
jury
decision.
is outside this door. They're not brought in
I'm
yet.
informed that the jury is outside the door.
To be respectful of their time.
They're not in the courtroom.
I'm
They're not
asking
present.
you to be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The
satisfaction.
record
It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to
Are you
follow
going to
the
answer
court's
questions as a public
ruling?
servant on why you're making up laws that are not in the Illinois versus Allen and never utilized
All
the
right,
mute button? It
can go
never
back
said
to the
anything
jury.
about a
Thank
mute
you.
button.
It is clear
Why
that
am I
Mr.
being
Brooks
muted?
has absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks,
Your
you have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not-
argument.
Your Honor,
you will
can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant-
invite you back over when it's time for your closing
you can't invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other courtroom when I can
and
do
you'll
so
mute me,
without
which you can't lawfully do.
interruption.
You can't lawfully mute me. Now you're trampling over my First Amendment.
I need it quiet in the courtroom, please. We are back on the record. The appearances are as they were before, except that Mr. Brooks has been removed to the other courtroom. He is insistent on making a record and an offer of proof. We are not in the midst of a trial where the court's made an evidentiary ruling that will require the preservation of the record by making an offer of proof. Thank you, everyone. Please be seated. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead. Hold on one second. Mr. Brooks, do you have an objection?
I thought I was supposed to be unmuted.
You are now. All right. Attorney Opper, you may start.
Thank you, Judge. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Opper, I'm sorry for the interruption. Your objection, sir?
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
All right, your objection's noted. It's overruled. The state may continue.
You must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Darrell. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77. It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize for my math skills. 68 through 73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that misstatement. We're going to talk about counts 1 through 67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail with 2 files in Milwaukee County facing felony charges. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background. First degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Well, I got.
Count 4, Jane Kulik. Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there, we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. We are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt there's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Hopper, your objection, sir?
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute or not. You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
I apologize.
We showed you at the very beginning, remember our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Hopper, your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted. It's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney Hopper.
how can speculation be made to what was saw? if
Your
that was never
objection's
testified
noted.
to?
It's overruled. Continue, Attorney Hopper.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one. I'm sorry. Going back to my street number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning. This is the area. We showed some videos of the group passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here telling of their 4 different efforts to stop him. Intentional. Sergeant Wanner's back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on, and he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop. Anywhere along the way, one of the officers testified to it. I think it was Officer Schneider. This was an accident, and he mistakenly wandered onto the parade route after passing all this, and he mistakenly wandered onto the parade route. At any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. Didn't. It was intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's intentional.
Mischaracterization of the evidence.
Noted, overruled.
His conduct when he left the parade route, we'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident. It wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never stopped.
I didn't even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please. That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opper.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long are we going to mischaracterize testimony?
Sir, it's argument. I've heard nothing improper. Your objection's noted. It's overruled. You may continue, Attorney Opper.
Thank you.
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged, he's angry, flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt, for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts. Right? That's where it starts. Nicole White, our first victim, walking with Remax and hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car and then fall off and drives over her body. He doesn't stop. He keeps going. Runs through the kids over by the Steaming Cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the Steaming Cup. They were struck by the red SUV, driven by Darrell Brooks. Keeps going, plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them. Keeps going, gets down here to the end, and goes through the Catholic community. The witness, remember Holly Berg, she testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They looked like bowling pins. And when you saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning caused this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why, other than the rage. He's right. You cannot read minds. Neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking. And it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see if you direct your attention to the left side of the screen is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play. Keep watching the left side of your screen. That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
I'm sorry to interrupt. Your objection, sir?
How can you tell the jury what they supposed to think?
It's proper argument. Your objection's noted. It's overruled. You may continue.
I will argue that it's. I would say that it's improper, and I move
Mr.
for a
Brooks, I've made
mistrial.
my ruling. I'm going to mute you if you don't follow the rules.
Exhibit
I move for a mistrial.
Exhibit 152, clearly intentional conduct. States Exhibit 93. We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings. That's intent. Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happened to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this, because this man in this picture is the same as this man in this picture, wearing this sweatshirt. It's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the play set that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man, and it's that man, and it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you through his questioning of witnesses about, I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
I'm sorry. Your objection, sir?
Your Honor, with all due respect, I would appreciate the quote-unquote language what does she mean by shenanigans and this and that and the third?
Sir, your objection's noted. It's overruled. The state may continue.
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would have been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's nothing
I just-
improper. It's
I
noted.
just
It's
wanted to-
overruled. She may
I
continue.
just wanted to be fair.
You'll have
Your
an
Honor. That's it.
opportunity to respond, sir. Please let her finish.
So I can rebuttal?
Go ahead, Attorney Opper.
Thank you. I'm going to conclude my comments with this, folks. I'm going to show you the video, a stitched together video of all the carnage caused by Darrell Brooks, and I apologize.
It's together.
This is important that you know what he did. It's important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? He drove right through them without a care in the world. The grannies dancing their way down the street. Perfect step, every one of them. Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. Time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video, but please, I ask you to add up the evidence. Use the map. 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts, please.
Thank you. Before we continue with Mr. Brooks's closing arguments, I'm going to take a short break. All rise for the jury, please.
I'm muted.
No.
The jury should know that they can nullify.
You are muted now. The record should reflect that Mr. Brooks is now present in the main courtroom. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
That request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There is no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of you said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I will hope it proves subject matter jurisdiction on the record, too.
All right. I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I
defendant.
accept for value and return for value this document, as it is not based in lawful law, and it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I've requested that they be brought out. They're on their way.
Were you aware
Please
of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
All right.
So that is a tacit agreement.
Record to reflect the jury is coming out. Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves to
Mr.
need
Brooks,
to know.
this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you inform
They will
the
be
jury?
informed of the law.
Did you inform them that they
Mr.
can nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to. When ready, I just want to know if the jury was informed that they can nullify the law.
Mr.
That they
Brooks, you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury. Thank you. Please be seated. Mr. Brooks, you do not have a right to request jury nullification directly from this jury. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice, so you can't coerce me into a constitutional right waiver when I have not waived the constitutional right, and I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me the constitutional right in
I have
open
not
court
made such
on
a
record?
determination as of yet, but you can forfeit your constitutional right
Under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant would forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how is that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not
to
prepared to
be
make
able to
that
testify
ruling
to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not be
delay.
taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And
arguments.
you made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third time.
Okay, now you can say
So,
two.
Mr. Brooks, I'm advising you yet again. The
I
time
don't
has now
consent to
come.
being called
That's
that
another
name, Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You
And-
were brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
it's
you
not
are
trying
going
to
to
give.
let me ask you a
No,
question.
hello. I'm not trying to give any
Sir,
jury
you're interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your attention.
You just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
you
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing.
disregard
I just told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Vjerkas says and stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed.
the-
I just want them
Sir,
merely to be informed.
You can
That's it.
call it informing, making them aware.
Yeah, they
Whether
should be aware
You
of
are
the
not
rights.
allowed to make them aware of their power to nullify. That
How
is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have,
have?
sir.
I'm not giving a new jury instruction.
That is
That's not what
because
I'm arguing.
There is no jury instruction for jury nullification,
Yeah, I'm
sir,
not- I'm
because
not-
it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me that
I'm not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is informing them?
It's an inherent power that they have. They are not to be instructed on it. That is very clear in the law. In addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sirs, I'm not going to read it all. It's many, many pages. But the bottom line is it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr. Brooks,
it never was brought up.
If you
but
think
then when I raised the issue, Your Honor, let me finish.
I'm not prepared to deal with an argument on jury nullification.
I didn't say that's not what I said. That's not what I said. In all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell.
Why was I kept in there?
So that my clerk could finish
adding a jury instruction that was not there.
76 verdict forms, and it's ×2 because there's a guilty and a not guilty for each. No, let me finish.
So why did I have to sit here for that where I could have just went to my cell and had it delivered? We had this at the end of last night before you called recess.
I'm not going to debate that topic with you.
We had a whole conversation about
Mr. Brooks, you
me
are
bringing up about the jury nullification,
disregarding this court. You
can
roll your eyes at me
because
all you want.
It's ridiculous, Your Honor. You just stated that they have the power to nullify any law.
If you would like,
but then
I will read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
Under what lawful law?
Under State versus Anthony.
It doesn't refer to that.
State versus Anthony may not have dealt with.
It hasn't dealt with closing arguments.
The right to a closing argument, sir, but the reasoning,
you just said it right there,
nonetheless, is fully applicable.
No, you can't change the law, Your Honor. You can't change the law. That's practicing law from the bench.
Law, sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm not
practicing
law from the bench.
You are. If you're changing, Your Honor, you're attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just named. Not
Mr.
Illinois
Brooks,
versus Allen.
I would like to make a record. Would you please show the courtesy and respect?
I will, Your Honor. I will.
All right. So looking at the Anthony case, all right, and that case starting at Head Note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights: waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there. I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture: doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on. The court, that is the Wisconsin Supreme Court in Anthony, as previously noted, we have held that the right to testify is subject to waiver, not forfeiture. forfeiture insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper, and unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor. I object to that ruling.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not one time did you, hold on, I let, Your Honor, with all due respect, I let you make your record. I didn't interrupt.
Go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I've just cited, sir, I'd also point you to State versus Bajurkis, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments, but not the prosecution. How is that fair? How is that balanced?
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification.
It's
that
not
is
defiance.
Requiring
It's
me to address this issue and to tell you very
Your Honor,
expressly
I
that is the rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record, but
May
my
I ask
rule
for legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted and will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and inclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your Honor,
a court of
because-
appeals, not this court.
No, I'm supposed to be in this admiralty court because you haven't. If we're under Article 3, then we should be in common law court. That hasn't even been addressed. If we're in a common law court or admiralty court.
That's a baseless argument, sir. I don't even need
And
to
what
address
law
it.
and fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also-
please
you're
let
also-
me,
but
sir,
listen,
you're
you just
interrupting
made
me
a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't.
on
Your Honor,
the issue
that's a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to be
circumstances of
fair.
this case and your insistence on arguing jury nullification has resulted in
I
this
haven't-
court creating this rule.
I haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why can't they be
nullification.
informed of their power?
Because it would violate the Bajorkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how I've outlined that
oral
to
motion
date.
for a
I'm
legal
not going to
finding of
declare that
fact.
at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't do
to
that.
Present a closing
Under
argument.
what lawful law can you?
And then if you continue to interrupt
Under what
me,
lawful law?
you will be removed to the other courtroom as I complete
So I'm being
the
held in
instructions.
contempt again. Is it civil or criminal?
All right, go ahead.
May I ask the court to consider perhaps an alternative? And I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Objection to that.
The proper
I don't
thing
think
to
that
do,
I should
I
be
think,
talked
Your
down
Honor.
Stop interrupting
I don't
Attorney
think I
Ocker,
should be
please.
talked down to.
Allow him to make his closing argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law, and we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction this court could even give, telling the jury that they are not at liberty to disregard the law. But we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
I'm certainly willing to try that.
That's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Your Honor, I object to that.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For
out.
the record, may I respectfully request the legal reconsideration of your ruling? So is that a tacit agreement that you don't have to answer my objection, Your Honor?
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Under
The jury's
based on what
coming in.
law or
All rise
fact?
for the jury, please.
Based on what law or fact? Because I'm going to inform the jury of their power. They deserve to know.
Thank you, everyone. Please be seated. Go ahead, Mr. Brooks. Your closing argument, please.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties, being the jury. The fact that you and you alone have the power, not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't true. You should be informed that you have the power to nullify any law that you don't agree with.
Objection. Move to strike misstatement.
Sustain.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart. What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event, it should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year for the families, mostly, and that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the thing from the prosecution here has been intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? For a year, I've sat and gone through this feeling so powerless, letting other people run with the narratives, sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself, I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn, while attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model of 2010 Ford Escape, the vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection. Misstatement of the facts. Facts not in evidence.
Was in fact.
Improper argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford.
Objection.
For those
Facts not in
models,
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies.
Mr. Brooks, move on.
It's information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection. That is
It's
completely
information.
inaccurate,
It's
Your Honor.
information.
There's an objection. Hold on.
Strike.
Go ahead.
Move to strike statements by
Sorry
Mr.
for the
Brooks.
interruption.
Facts not in evidence, Your Honor, and it's a complete misstatement.
Sustained. Strike
How's it a
the-
misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? information that you definitely should have been privy to. DA says the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did. Moments that I'll never forget. And yet they say disregard, utter disregard for human life. They made reference to a rage, as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself, what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does. DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill, and it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? They speak as someone who's known someone for years, which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. With someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people? Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. I've heard testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant, and the people have been disregarded. Makes me wonder, does the DA even care about those people? There's been prayers going up every day. There's been suffering on both sides. There's been threats, hate mail, because of the narratives that's been put out there, the misconceptions that have been put out there, the lies that have been put out there, lies that have caused my children not to be able to go to school, to be bullied, for my mother to have to leave her home and stay at a hotel because she's afraid for her safety, because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8, attempting to answer her questions that she's asking and still continue to shield her from what she sees, what she hears. Having a newborn son that I haven't even been able to meet, haven't been able to hold, touch, kiss, having to navigate everything that comes with this whole situation while still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you, and just been praying and asking myself, how could this happen? Not just for the people but for everybody involved, the community too. How could this happen? How the hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once, because I know it wasn't. As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show, may be hard to believe, but trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine. So again, I go back to all these exhibits, go back to everything that's been shown, everything that's been testified to, everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books, everything. You have the decision. You and you alone. All of you. You have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons. Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision. It's almost like that message, well not message, but that writing when we're in our vehicles and we have that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear. I can't speak for anyone else, but me, myself, I believe in Jesus Christ. That's how I was raised. That's what I believe in. None of us are perfect, but I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised. For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear. And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen. A lot of lives were changed that day, mine included. God's way is not our own. And no matter how much sometimes we want to question, we have to have faith. Look inside yourself. Look inside yourself and make the right decision. Look inside your heart. You have everything in your hands now. Everything. Do what's right. Do what's right. Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision. Do what's right. Make the right decision. It's hard to think about my younger kids getting older and at some point having to explain everything to them. Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much. I got a letter the other day from my youngest daughter, and she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, Dad, and this is from the letter, she said, Dad, why are people saying all these mean things about you? I haven't read the rest of that letter yet. The rest of that sentence said, that's not the dad I know. Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them. Never has been, never will be. So before I close my statement, I just want to say, open your hearts. Go inside yourself when making this decision. Have no fear. Pray. And do what you know is right. You know is right. Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture. Above everything, whatever you decide, make sure you yourself can live with it. Make sure you can live with it. That's the magnitude of the power that you have. Just like this tissue is in my hand, you have everything. Be at peace with what you decide. Have no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a lot of living ahead of us, Lord willing. Don't look back and kick yourself in the behind. It's been about 3 weeks with you. took a lot of courage and a lot of guts to pause your life for this, to put important things on hold, to basically stop your life. You should be commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot, and you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. And you guys had the guts to do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this. I know it's probably not proper, but you guys deserve a round of applause if you could get one. Thank you guys sincerely. And I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right. Thank you.
Thank you, sir. Before I give the state an opportunity to present rebuttal, please stand for a minute. So please stand. All right, have a seat, please. And Attorney Opper, I did time both closings. You have 13:28 left.
Thank you, Judge. I don't think that'll be an issue. Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son, never once acknowledges the Sorensen family, the Owen family, the Duran family, the Hospital family, Kulik family, Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones. I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder, as he claims to, for him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going, and have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You'll be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. All rise for the jury as they're excused to begin their deliberations. She did previously. But
Yeah, I'm going to need all of them, and then I'll
Yeah, no,
take
I
them
know.
down and all
But
that
those are
stuff.
the-
Yeah.
Is that closed?
No,
All right. Thank you. You may be seated. As far as how late, I will let them deliberate tonight. We have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner. Anything else the parties would want me to address at this moment from the state? Anything from you, sir?
Yep. So essentially, I'm gonna have to stay here while they're delivering. I'm gonna be able to go back to my unit, use the phone, shower. It is shower day for my pod. We only get 2 shower days a week.
So here's what could happen though, sir. I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that. So let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well, okay?
And one more thing.
Go ahead.
I was curious. 61 charges for the reckless. 61 injured parties did not testify. So how does that work? How are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law, and I guess that's all I can really say about it at this point.
I got a point though.
I'm sorry?
I got a point though.
I'm not going to comment on that, sir. Of course, the state bears the burden of proof, and they have to convince a jury beyond a reasonable doubt. For better or for worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case or the close of the evidence regarding any legal arguments you may have had regarding those issues. And so at this point, the jury has the case and they will determine their verdicts. If there are issues of law that you want to raise after the verdicts are received, then you'll have to make that determination.
Yeah, that has to be raised because essentially you can't, if no injured party testifies, then it shouldn't be a charge.
I disagree with that characterization, sir, but there is frankly no motion in front of me based in law or fact, so for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you're saying I need to make a motion?
So what I will say at this point is I do have one issue that I would like to raise with the parties. I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming and I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today so that the parties are advised of that. But I will do that. Let me confer with the Sheriff's Department about your request. I'd like to take in about 30 minutes address the issues that I need to address or the issue, and I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great, and I'll confer with the Sheriff's Department and have a more definitive answer for you shortly, okay?
Can I get my filings?
You want the originals back. If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals back. They will have the date stamp. They don't have a time because they were filed in court.
See? I didn't interrupt you, see?
I'm sorry?
I said, see, I didn't interrupt you.
Thank you. I appreciate that. I would like the parties back in about a half an hour. Thank you. Unless they have a question sooner.
Your Honor, do I have to go in that holding cell or do I got to get
Thank you. All right. It's 7:05. We're back on the record. I wanted to advise the parties that earlier today I received information from the clerk of court. She had received an email that the person sending the email had found a post on Justice for Darrell on Reddit. So it's a subreddit. I'm not familiar with how Reddit works, and that the thread on the Justice for Darrell Reddit site was claiming to be a member of the jury pool. And I am going to provide the parties with the information that I was given this morning. It's a color copy of the attachment and the email that was sent. The email was received by the clerk of court at 9:10 a.m. Then my clerk received a notification at 9:30 a.m. that clerk of court wanted to speak with me. You may recall this morning I stepped off the bench for a little bit of time. I read through the information that was provided to me, which was an email, and then the attachment, which is a color print off. Looks like the person took a screenshot, and that the anonymous post claimed to be a member of the jury on the case, and here are my thoughts on the trial and on this subreddit. And apparently, again, it's a subreddit called Justice for Darrell. All those, Justice, the number 4, and Darrell, all, no spaces. I then had contact with Captain Dussault, advised him that this should be investigated, and basically turned over the matter to law enforcement for a full investigation. At that point, I made a determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions to the jury and ultimately the closing arguments, and then turning the case over to the jury for deliberations. Of course, I am concerned about the integrity of these proceedings, and I will take whatever action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information that this is in fact a member of the jury, but I will leave that for law enforcement to determine. And if, of course, if need be, at the conclusion of the case, when the jury reaches a verdict, I certainly will consider whether any questioning of the jurors at that point is warranted. So that's the information I wanted to provide. Again, copies of this information will be provided to the parties, and there is a full investigation underway by the Sheriff's Department. I have no further information about it at this time. I will not be the judge that will further be reviewing it in terms of any requests related to that investigation. I will simply be handling whether any requests as relates to this case in particular. And we'll provide those. Go ahead.
What is this?
All I can tell you, sir, is that there is apparently on the internet, on a site, or maybe it's an application, I'm not entirely sure, called Reddit. There's a subreddit that is entitled Justice for Darrell, and it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors. That, of course, would be a violation of the rules that I set up for the jurors, which is why I turned over the information to law enforcement so they could make a full and complete investigation.
For the record, I accept for value and return for value these documents. I'm confused.
At this point, sir, I'm providing the information. I trust that the parties will review it, and if a party believes that any request needs to be made of this court, an appropriate request will be made. But at this point, I'm just advising the parties of the information that I have. And I will add this. I will, of course, it's important that the results of any investigation be turned over to the parties. I don't know how long that will take, but that is also my direction. That was really the only direction I gave to law enforcement, is that the results of the investigation that be turned over to the parties.
Was this... Oh, I'm sorry. Was this just found out about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. and then that email and the attachment, I'm aware of a second email that was sent to our clerk of court at 10:02 a.m. And I think when we stepped off the bench following the case being given to the jury, I was advised that other emails had been received throughout the court system. I simply said, obviously, that information needs to go to law enforcement. I haven't seen it, haven't reviewed it, but any person who works in the clerk of court's office who has received an email that email about this topic will be forwarded to the Sheriff's Department. Their forensic unit is handling the investigation, to my understanding. Attorney Upper, did you have a question or something to state?
Yes, Your Honor. I just wanted to state for the record that I have also received similar emails at my office this afternoon. They were sent not to me directly, but to the District Attorney's office website, and in viewing the content of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not true. And also, upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and to some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's why it's under a subreddit called Justice for Darrell, And I don't believe there's any reasonable reading of this post that would lead someone to believe that it suggests the juror harbors substantial or material prejudice against the defendant.
Can I say something, Your Honor?
Go ahead.
Just briefly skimming through it, I do want to state for the record that I have no involvement with this. Really like shocked like this even came to light. I will say, just by skimming through it, these are definitely things that have been talked about in the court. So common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. It's no other way.
Well, actually, the proceedings are live streamed worldwide, Your Honor, available on YouTube worldwide, so I don't agree with that assessment.
I mean, it's pretty obvious that this would come from somebody who's actually, I think it's pretty clear.
Well, I'm leaving it in the hands of law enforcement to do a full and complete investigation. If either party believes any further action needs to take place as it relates to this particular jury, then I trust they'll file the appropriate request with the court. So with that, the courtroom, go ahead. I'm sorry. Something else, Attorney Alpert?
A different topic, Your Honor?
Oh, sure. Go ahead.
While we're all together, I just wanted to address exhibits and what the court's procedure would be. We have no objection to any exhibits going back to the jury room if they are asked for. So as long as we're all here and we have some time, maybe we could discuss that.
Do you have any position on that, sir?
Yeah, I would object from the standpoint that I would need to see any exhibit that's being asked about and the relevancy of that exhibit being asked for. I think that's only fair.
Exhibits that have been received, a relevance objection would no longer be valid because the court has already ruled on the relevance and the admission of the exhibits. The issue is whether it goes back to the jury room. Jurors can ask to view photographs, written documents. They can even ask to view the videos. The videos would need to be done one of two ways, either which requires everyone to assemble because we do have the technology to play them directly to the jury room, but that simultaneous with that is it would be played in here. So everyone would be seeing what's being played in the jury room at the same time, so that does require the parties to be in court. That allows the jury to continue with their deliberations, talk about what they're seeing, etc.
So can the jury see in here now?
No. I'm talking about a video. We have the ability to play it directly. There's a TV. I should have said that. Probably not too. Why would you know there's a TV in the jury room, right? So there's a TV monitor in the jury room that is connected to the technology in the courtroom. So whatever is playing here could be a still photograph, could be a document, could be a video. We can play in the jury room at the same time.
So it would be only the exhibits that's been
received.
So
correct.
Nothing new. Nothing's going to come out of the blue and be like, oh, yeah, we're going to.
Only what's been received during the trial. If it would be helpful, I can have Madam Clerk give you the printout of the exhibit list that shows everything that's been received, if you would like.
That's about like 7,500.
There's a lot of exhibits,
There's a lot of exhibits.
But I'm willing to have her print it off if you would like it.
I think it'd be helpful just in case. I'm guessing at some point that will come into play.
Right. For example, they may come back and say, we'd like to see Exhibit 15, which is the map, the large map of the parade route. Okay, so do you have a position on that? If the jury requests an exhibit, do you want the court to rule on it individually, or do you agree that if they request an exhibit, it can be released to them?
A rule on it.
All right, fair enough. Anything else from you, sir?
Yeah. Did you talk to the jail, the deputies?
I did. Thank you for that reminder. The jail has asked that I follow the standard operating procedure, which is to have you in central holding and not up at your cell. But if need be, I'm willing to order that they give you a shower later if that's helpful, whether it be tonight or tomorrow morning, okay? So even though you're going to stay close by, I'll work with the jail to make sure that you're given that opportunity after we're done for the night, okay?
Yeah, at least let me take a shower.
So I've been told there is a question that will be coming out shortly, so don't go anywhere.
Don't choke me, Judge.
What?
I said don't choke me.
Choke you?
Yeah, because you know what I'm about to say.
What are you about to say?
Subject matter jurisdiction? You knew I was about to say that.
Sir, I'm not going to address it. I already have. All right. There are requests for 3 exhibits. They have a request for 3 exhibits, 15, 5, and 55.
You said 15, 5, and...
55.
I was going to say, I don't know. I know 15.
15 is the map.
15 is the map, yeah.
Any objection to the map, sir?
Yeah. I want you to rule on everything.
I was going to go one by one. So I'll start with Exhibit 15, which is the map. What's your position on that?
My position is, at this point, what is the relevancy of the map? I think it's been seen a million times. I know it by heart now. That's probably the only one I know by heart.
And what's the state's position?
Yes, we absolutely, there's no reason not to send that back there, Your Honor. There's 76 counts that they need to work through, and to assist them in identifying which victim is which and which group they were with and where they were on the road. Absolutely, there's no reason to hide that from them. It's helpful to them in their deliberation.
All right, I will send Exhibit 15 back. All right, the next exhibit is Exhibit 5. That is the photograph of Erica Patterson.
Oh, I definitely object to that. Seeing as how it was supposedly 2 incidents, one of which didn't even happen. The prosecution sent paperwork to acknowledge that it never happened. So I don't even, it's too dicey with that. What incident would 5 be referring to? One of which
The
never
battery
happened.
count.
And then one, I don't even know what I'm looking at if I look at 5.
What's the state's position on 5?
Again, Judge, there's no legal basis to exclude that from the jury. The injuries that are alleged to be associated with count 77, it's directly relevant to their deliberations.
There is no count 77.
Count 76. You are correct. It is count 76, not 77.
See why I'm confused?
It is proper for Exhibit 5 to go back to the jury, and that will be sent to them. Now, Exhibit 55 is a video. How long is that video?
15 seconds.
Any objection to playing for the jury Exhibit 55?
What exactly is in Exhibit 55? I don't.
It's a video from Curry Insurance facing eastbound showing the grannies being struck. We are requesting that it be viewed by the jury in their deliberation room.
Your response, sir?
Yeah, I don't object to it. I guess my objection would be hard. It would be hard to say why the jury would request it. I don't know. I'll just let you rule on it. I don't particularly. There's so many videos that's kind of like the same video anyway.
I will show it to the jury. I will play that for them twice through. This is what I have proposed to write on the note back to the jury as it relates to all 3. Exhibits 15 and 5 are attached. Exhibit 55 will be played for the jury 2 times, hyphen the clip is 15 seconds.
Any reason why it would need to be played twice? Any
Yeah,
reason
if
why
you
it
could-
need to be played twice?
That's my practice, at least on short video clips.
So what about if they request for a long video?
Then I'll make a determination then.
I set for value and return for value these documents, Your Honor.
Thank you.
Your Honor.
Yes, sir.
About this Reddit, is that how you say it, Reddit?
That's my understanding.
This particular person is who the email was sent from, the person at the top of the page?
That's my understanding, yes.
Were they identified to have any connection with the trial in any way?
I'm leaving the entire investigation in the hands of the Sheriff's Department. I can't answer that. I'm going to step off. Obviously, the courtroom remains open.
Subject matter jurisdiction, Your Honor.
I decline to address that, sir.
Will we be addressing it for the record?
Mr. Brooks?
What's the significance of seeing it as different speeds? Was that in the question?
They just said, can we see Exhibit 55 at 40% speed? Obviously, I don't recall specifically if this video was shown at a reduced speed, but many of the videos were shown at reduced speed during the trial. That was allowed. I think it's proper to also show a video clip to the jurors if they request it at reduced speed. So I'll grant the request.
What would be the significance?
The significance is the jury's requesting it, sir.
I'm saying at that speed.
That's their request. I can't tell you the significance for them. I don't want to speculate. But I think it's proper, given the technology that we have available and what was done during the trial.
So why even ask me if I have a position?
Because that's what I'm required to do, sir.
But you're not required to address subject matter jurisdiction, which hasn't been proven for the record. I'm not allowed to answer any questions I ask. From your name,
Mr. Brooks, I'm not going to relitigate your case right now. And I've made my decision on subject matter jurisdiction, so your request that I address it once again is denied.
Of course it's denied. Of course, because you can't prove it on record. Come on now, it has yet to be proven. It has to be proven at some point. Or do I gotta go through the song and dance to get it proved?
Jury's ready?
That's 40% speed? Yay, nay?
Yes, 40%, Your Honor.
Thank you. You know, if there's another question, the court's going to step off. Obviously, we'll remain open. At 7:47, the foreperson provided a question through the bailiff. We request Exhibits 3 and 4. Exhibits 3 and 4 are videos. They are the videos from White Rock, I believe, elementary school, door 1 and door 2. My inclination would be to play each one time, since they're a little bit longer, and play them one after the other. From the state? Agreed. From the defense?
Objection.
Noted for the record. Any specific reason, sir?
The significance of both videos.
Their evidence, sir? And the jury's requested to look at them?
Will you be addressing subject matter jurisdiction on the record?
No, I will not.
Is that a judicial determination, Your Honor? Is that a tacit agreement, Your Honor? Is that a tacit agreement, Your Honor?
Exhibit 4?
I thought it was 2 people that got excused from the jury.
3. There were 15.
No, I'm saying I thought it was 2 from the 16.
No, only 1.
Well, you did say 2. You said one had got excused before, and then another one was getting excused.
No, I only excused 1. We've had 15 since the first juror was excused.
So what happened to that second one that had the COVID scare? What happened with that?
Mr. Brooks, I addressed all of that on the record. I'm not rehashing that now.
No need to get in your feelings. It's been a long day. I'm tired too.
I would agree.
I just thought you said 2. You said 2 on the record.
All rise.
Thank you, everyone. Please be seated. The record to reflect I have the 12 jurors who have been deliberating plus the 3